Okay, so it is 12:01. I will go ahead and get started. Good afternoon. My name is Archie Shamihan, and I'm the Vice President of Business Development at FedMine. Welcome to our series on government contracting with Maria Panichelli of Obermeyer. And today's webinar is on asserting and defending bid protests. Most of you hopefully know FedMine. We are a small business that is focused on providing accurate federal information to the world of government contracts. The presenter for today's webinar is Maria Panichelli, a partner and the chair of the Government Contracting Department. And I apologize for some of the technical issues that we had in the beginning. Zoom is constantly making changes and we are left to their mercy sometimes. Anyway, the agenda is going to be pretty simple. After the introductions, Maria is going to get into her presentation, and then we'll have a Q&A at the end of the presentation. But feel free to go ahead and chat us your questions as they come on, and we will address them towards the end. We would have liked to address it during the presentation, but with Zoom's changes, that might be an issue. Anyway, one of the things that, and we will be sending the presentations out to all the people that are on, so do not worry about that. Also, a little bit about FedMine, everyone knows us, but we do integrate the protest, GAO protest into FedMine. You'll see that it is searchable, and actually we also link the protest to the solicitation. So anytime you're looking at a solicitation, if that has ever been protested, you'll find a little link there. So I did want to point that out. And interestingly, I was talking to our CEO, and there's a link that way back in 2012, Willamette University did a study on protests that were done by, that were filed at the DoD. And I have a link to that on the presentation that'll go out to you, but it's also on our website. So that's just a little bit about FedMine. Not sure if you all have listened to our earlier two series with Maria, but Maria focuses her practice exclusively on federal government contracting and procurement, and she actually guides her clients through the entire life cycle of federal contracts. By providing comprehensive legal counseling, she allows her clients to successfully navigate the complicated legal requirements that are related to federal contracting while fulfilling their own business goals. Her prior legal experience in corporate litigation and risk management counseling has given Maria a very unique perspective. Recognizing that a client must focus on what is best for the business, her goal is never to unilaterally dictate strategy. She always helps to find a solution that not only solves the client's legal issues, but also advances that client's business plan and is consistent with the client's mission. Today's topic is actually one of my favorites. So Maria, let's go ahead. The screeners, the slides, everything, looking forward to hearing your presentation. Thank you.
Thank you so much, and thanks for hosting. And thank you everyone out there for joining us, and like our teacher said, bearing with us through the technical difficulties up front. Today we are going to be talking about asserting and defending bid protests, two very important tools when you're talking about either fighting for or keeping contracts. My name, I will just briefly do a recap of who I am and why I am qualified to talk about this topic. My name is Maria Panichelli. I'm a partner and the chair of the Government Contracting Group at Obermeyer, Redmond, Maxwell, and Hipple. Obermeyer is a full-service law firm. It's over 120 attorneys. We've been in business over 100 years, but my group focuses exclusively on federal government contracting. So we help prime and subcontractors that are doing business with the government or doing business on federal jobs all across the nation and abroad, all different agencies and all different lines of work and on all different industries. We help clients through every stage of the procurement process, which ranges from compliance and performance counseling, REA's claims, small business procurement, subcontracting issues, and of course, a big piece of our practice is what we're going to be talking about today, which is asserting and defending bid protests. So before we jump in, just want to reiterate what Archisha said in terms of housekeeping. Doesn't look like I'm able to get to the Zoom controls to see questions as they come in, but please send in questions as they come up. I will leave time at the end to try to address them, and if we don't get to them today, you can always reach out. My contact information is on the screen, and if you've got a question that we don't get to today, or if you've got a question that comes up later after today, feel free to reach out. All right, so let's start with the protest primer, and some of this might be a little bit recap or a little bit too simple for those of you who have been in the industry for a while. But what I find is that a lot of times with protests, you've heard enough and you've learned enough and you've heard enough buzzwords that you know some stuff, even if you're a very sophisticated and experienced contractor. But the regulations change and kind of case law and practice changes frequently enough that it might be that whatever you learned a while ago isn't right anymore. So my experience is that contractors, if they know things about protests, which many of the more sophisticated and experienced contractors do, what they might know or what they might think they know is actually wrong. It's just enough to be dangerous. And that's not because they learned it wrong. It's because something has changed, or there's a new interpretation, etc. Or they learned something and it doesn't apply across the board. We're going to talk about kind of how different protests are handled differently. And sometimes if somebody fails to make that distinction, you're going to be confused about what rules apply. So I think it always makes sense to begin with, a very basic approach, get a lay of the land and kind of go over the fundamentals, and then jump into using protests as an affirmative tool to assert a protest and go after a contract award you want, and then move on to defending protests. So on the primer about a protest, very simple idea, but if you're following through the procurement process, and obviously protests happen during the procurement process in terms of who is getting the award, it all starts with a requirement. The government identifies a need that it has, whether it's however many widgets to sell, or to give to the VA hospitals, or construction of a dam, or IT services for Army bases. They identify something they need. The government says, hey, we need this. The solicitation is put out on the street seeking for people to respond and to compete for the requirement for the items or services that are being procured. Contractors submit responses to the solicitation. Then the government, the agency, does an evaluation of those responses, a comparative evaluation of contractors. This is the source selection, quote unquote, and then an awardee is chosen, right? So pretty simple. But I want you to keep in mind kind of this trajectory or this chronology, because we're going to come back to it later and talk about, which of these bullet points is a jumping off point for what type of protest. Other thing I want you to kind of wrap your head around early is the difference in the lingo. You will hear people say protests, and sometimes that means bid protests. Sometimes what they really mean is a size or status protest, because they are not the same. All three of them are protests in that they are a challenge to a contract award, and all three are raised by contractors as opposed to by an agency itself, et cetera, or by the contracting officer. These are usually raised by contractors that are competitors that are disgruntled that they didn't get the award, but what they're challenging is different. If you're talking about bid protests, the contractor, the protester that's filing the protest, is alleging that there were improprieties in terms of the source selection process. They're saying that the agency failed to comply with applicable laws or failed to follow the terms of the solicitation, etc. Size and status protests are a little bit different. With size and status protests, you're not talking about a situation where the agency, allegedly did something wrong. The agency made the wrong decision. The agency didn't follow the terms of the source selection. What you're talking about instead is, hey, this company that you're giving the award to isn't eligible. It's a small business set-aside contract, and they're not small. It's an 8A set-aside contract, and they're not socially disadvantaged, et cetera. The idea is, bid protests, challenging the award decision itself, something that went wrong during the award decision, and size and status protests are challenging the eligibility of the awardee. Another basic concept to understand is what laws govern bid protests. Of course, like most things with government contracting, the FAR is going to be your starting place, the Federal Acquisition Regulation, FAR. That's kind of the Bible, or like the seminal place where you get a lot of the regulations dealing with federal government contracting. Specifically, FAR Part 33 deals with bid protests. There's also going to be supplemental agency acquisition regulations depending on what agency you're dealing with. Some of them have supplemental agency acquisition regulations that apply. So the protests themselves are dealt with in Part 33 of the FAR, and then, like I said, some agencies will have supplemental regulations. But there's also things spread throughout the FAR, like, FAR 15 talks about how a FAR Part 15 procurement should be analyzed. FAR Part 14 talks about how a sealed bid procurement should be analyzed. So the procedures are going to be laid out mostly in FAR Part 33, but the substantive law or the substantive basis for your challenges might be laid out in other sections of the FAR. In addition, the small business regs, and by that I mean Small Business Administration, SBA, and the VA regulations relating to eligibility for their programs might come into play. They're more likely to come into play on size and status protests than they are on bid protests, but they sometimes can become relevant in the context of bid protests as well. And then finally, the forum rules. And by that, I mean when you file your protest, and we're going to talk about where you file it later in this presentation. But if you file it at GAO, you're going to have to be, cognizant and make sure you're compliant with the rules of the GAO. If you file at the Court of Federal Claims, you're going to have to make sure you're cognizant and compliant with the rules at the Court of Federal Claims, et cetera. So this is just kind of an overview of the laws that govern the bid protest process, both in terms of procedurally and in terms of substantively. Obviously, if you have questions, you should consult a legal professional. So one last thing before we move on to talking about asserting bid protests in detail. The other thing you want to keep in mind are kind of what are the critical questions and considerations. And this is kind of the driving set of questions that's going to, I guess, really dictate the answers to a lot of things we're going to talk about on the upcoming slides. There are differences in how protests should be filed, how they should be structured, what deadlines apply, depending on how you answer these questions. So one of the most important questions you're going to want to ask yourself is what method of procurement is being used? Is this sealed bidding under FAR Part 14 where, lowest price, as long as you're responsive and responsible, the lowest price bidder is going to win? Is this a FAR Part 15 contracting by negotiation where you have a lot of non-price evaluation factors? If it's a FAR Part 15, are you talking about something where the government went into competitive range and opened discussions or not? Was it an LPTA, lowest price technically acceptable? Similarly, what if it was FAR Part 8, an FSS or a GSA schedule contract issue? What if it was a GWAP? What if it was, a simplified acquisition? What if it was a commercial items contract? These are all things that you're going to need to understand, or your lawyer is going to need to understand to figure out, okay, how would a protest be filed in this case? And the reason for that is it's going to change whether or not you get a debriefing. It's going to change what your deadlines could be. It's going to change the evaluation scheme, or kind of the margins, the guidelines within which the government had to put together an evaluation scheme. And we're going to talk about all those things in more detail, as we go forward. I just want you to be aware, that's one of the main questions you need to be thinking about and talking about, early in the protest process. What type of procurement was being used? What section of the FAR are we operating under? Second part is what type of contract is at issue? Are we talking about an IDIQ contract? Are we talking about a task order under an IDIQ contract? Is this a set-aside contract where maybe the small business eligibility issues and those regulations come into play? Is it a government-wide acquisition contract, et cetera? And then finally, who are you dealing with? Are you dealing with one agency that's procuring this on their own behalf? Are you dealing with two agencies? Is this the GSA procuring it on behalf of the Department of Health and Human Services? Is this the Corps of Engineers and the VA working together on a construction project? Which role is which agency playing? Who's really the procuring agency? Is there a difference between the procuring agency and the end user or end customer? Also, this becomes important because there are certain rules that apply to DoD, defense agencies, that are different than what would apply to civilian agencies, both in terms of certain jurisdictional thresholds and debriefing rules. And again, these are things we're going to talk about in more detail as we go forward. These are just, you need to be aware that these questions are becoming very important in the bid protest context, and you're going to want to try to get a handle on those early in the process to kind of understand how to guide the protest process from there. All right, so with that fundamental building block primer over, let's move on to asserting bid protest. And we're going to talk about how to use bid protest as an affirmative tool to go after the contract you want that you were not awarded, but that you think you should have been awarded. First off, where are protests filed and heard? Remember I said that, one of the things you need to keep in mind in terms of what law is going to govern is what forum rules are. And that obviously depends on what forum you go to. So there are three general options when you're talking about bid protests. The first is to file with the contracting officer. That's an agency protest. In other words, you go straight to the agency and say, I think you just made the wrong decision on this procurement decision, on this award. It should have gone to me and not to my competitor. You can go to the Government Accountability Office, the Comptroller General, which is GAO, or you can go to the Court of Federal Claims, which is COFC or COFC. Now, this is a personal preference or a personal opinion thing based on my own experience filing. Generally speaking, I prefer to go to GAO, and I think, I don't want to speak for my colleagues out there and my peers out there, but I think generally speaking, that's most lawyers' kind of default position, is that you're going to the GAO. I go to the contracting officer or to the agency when it's more of an administrative challenge, kind of a clerical error thing. Like, I think you didn't carry this number over correctly, and we're not getting into a lot of analysis. If I can just point out that you made a very simple, almost clerical or administrative error, and we should have gotten the award, that's when I usually find it most beneficial to go to the contracting officer or the agency. Otherwise, I find it pretty rare that they ever overturn a decision that they just made. GAO, obviously you go to an independent body. You've got GAO attorneys that are kind of functioning like judges that are overseeing the process. You as the protester file something, and then the government or agency counsel steps in to defend the award. And we're going to talk about that a little bit more later. And then Court of Federal Claims, obviously you go to the Court of Federal Claims, which is like a U.S. District Court. It's the trial level court that deals with government contracting issues. It deals with REA and, CDA, Contract Disputes Act claims, and it also deals with bid protests. In terms of rules, remember I said that forum rules are important. I'm going to be talking mostly about the rules that apply to the GAO because, like I said, I think that's the default, and most protests are filed at the GAO. But where there's kind of a different rule that applies with regard to with COFC protests, I will specify that so that you guys can make sure that you understand the differences between GAO and COFC. But my default is going to be mostly talking about how this works at GAO. So the first thing to keep in mind in terms of asserting a protest is that there are different types of protests. The protests or the type of protest is defined by where you are on that chronology that I had a couple slides back. So it's really important to understand the procurement timeline, and it's really important that you act at the right time. If you don't, you could lose your right to protest. You could kind of prejudice yourself and limit your ability to file a protest and to do what you need to do to hopefully get the award that you were entitled to. So different types of protests have different, what I call kind of jumping off points. Remember that chronology that I went through, back in the primer section, and you're talking about, the government identifies a need, the solicitation is put out in the street, et cetera, et cetera. So I've put in orange on this slide kind of the different jumping off points. It's kind of within and in between these four orange items where the protests generally occur. And we're going to break it down piece by piece. The first type of protest and kind of the first timeline or first jump off point that comes up is pre-award protest based on errors in the solicitation. So that comes at that second stage. Government's identified a need, and now we're at the point where the solicitation has been put out on the street. It's posted on Beta SAM. Back in the day, it would be posted on FedBizOps or maybe on Dibs or, et cetera, et cetera. And you take a look at the solicitation, and there is something funky with the solicitation itself. That is when you start evaluating, all right, I think I have a pre-award protest based on an error in the solicitation. That is kind of the jumping off point. In other words, the solicitation has been issued. You have not submitted your response yet. You are evaluating the solicitation and you've identified a problem. That is where you think, is this appropriate for a pre-award protest based on errors in the solicitation? And what I mean by that, what I mean in terms of errors in the solicitation are things like these examples on this slide. Now, this isn't an exclusive list. There are other items as well, but these are the ones that come up the most often. Sometimes if the solicitation is just ambiguous or contradictory, there's a spec on page 4 that doesn't really jive with something that's on page 55. You've got one thing laid out in terms of how you're going to be evaluating offers on, in section M of the proposal, but then in the statement of work, you say something different and it doesn't really make sense, and those things seem contradictory, or at the very least seem unclear, and maybe we need to clarify. We tried to clarify during the question and answer, and you guys didn't give us a satisfactory answer, so maybe we need to talk about whether this is appropriate to protest at this point. Similarly, if you've got inclusion of prohibited terms, in other words, they've got clauses, FAR clauses that apply to a FAR Part 8 procurement, but you're dealing with a FAR Part 12 procurement or a FAR Part 13 procurement, or vice versa. They're not supposed to be in there. You don't want to wait and see how the government decides to apply stuff that's not supposed to be in there. You want to protest. And if they exclude required terms, you need to protest and make sure that those terms are put into the protest if they were improperly excluded. One of the big things that comes up is overly restrictive or unduly restrictive terms. So if you've got a situation where a solicitation is put out and they're making it a very, very narrow hoop to jump through, very hard to thread that needle, and you think that they're doing it either because they're trying to steer the procurement, one particular way, or because they just really haven't put any thought into it and they're requiring something that's completely inconsistent and makes no sense. That is, potentially an argument that the government is doing something that is unduly or overly restrictive. I'll give you a good example that happened with a client of mine recently. We had a solicitation that dropped, and it was a small business set aside, but the past performance that was being required was that the prime contractor, and couldn't include their teammates or their major subcontractors, the prime contractor and prime contractor alone had to have performed at least $29 million worth of work. They had to have at least 3 contracts for X amount of money that they performed at whatever percent. And when you did the math, it came out to they would have had to have self-performed $29 million worth of work over the past 3 years. And this was back before the small business runway extension. So in other words, they would have had to have performed $29 million worth of receipts. Their size standard in order to be eligible for the contract was 27 over the past 3 years. So see how that would be a problem? Basically, the government was making the past performance requirements so restrictive as to make it impossible for anyone that was eligible from a small business standpoint to actually meet the past performance requirements. That is an unduly restrictive or nonsensically restrictive in that case term. So you file a pre-award protest and you get them to amend and revise the solicitation, and then you go from there. Improper use of LPTA, lowest price technically acceptable. The government has recently put restrictions on when it is appropriate to use LPTA and when it is not. I know many of you out there do not like LPTA for understandable reasons, especially if you're in service industries. So keep in mind that if you see a procurement that's using LPTA, you might want to talk to an attorney. They might not be allowed to be doing that anymore under the new regulations. And if that is the case, then that is proper fodder for a pre-award protest as well. Set aside, rule of 2 or kingdomware issues, should this have been set aside? Should this not have been set aside? That is a pre-award protest issue. And then de facto responsibility determinations as well. So why am I spending so much time on this? Because this is one of the most important mistakes, or most dangerous mistakes that I see contractors make. They see the problems in the solicitation and they say, all right, well, we'll put our we'll put our response in, we'll put our bid in, we'll put our proposal in, we'll put our offer in, and then we'll see what happens. And if it doesn't go our way, then we'll say, hey, the solicitation was messed up to begin with. The problem is, if you follow that timeline, you waive your right to protest. You are going to be too late. And the reason for that is the deadline, and again, we're talking about the GAO, but the deadline to bring this type of protest is before you respond to the solicitation. So if you see a problem in the solicitation, you need to file a pre-award protest before submitting your bid or your proposal, etc. If you wait until after the award decision drops, if you wait until after you put your offer in, it's going to be too late. So don't roll the dice, don't hedge. If you see a problem with the solicitation, bring it up before you respond to the solicitation. All right, that's pre-award protest. Now let's go back to the timeline and see the next jumping off point. This is going to be one that applies to FAR Part 15 procurements where they're actually doing the competitive range thing. And for those of you who are not aware what competitive range is, on FAR Part 15 procurements, which are competitive procurements that use non-price evaluation factors as well as price, there is a procedure by which the government can say, hey, we got, let's say, 10 people responding to the solicitation. We got 10 proposals. We're going to take the best 8, and then we're going to do what's called opening discussions with those 8. We're going to knock 2 out, say, I'm sorry, you've been excluded from the competitive range. We're going to take the 8, we're going to open discussions with them where we tell them about the strengths and weaknesses of their proposal. We're going to let them modify and revise their proposal. We're going to get revised proposals back from everyone, and then we're going to make our decision. So it's kind of like a 2-phase process. And a lot of times what you'll see in the solicitation in these kinds of procurements is the government leaving themselves the option. They'll say something like, the government intends to make an award decision based on initial proposals. However, the government reserves the right, should it be necessary, to offer open discussions and solicit revised proposals from the offerers or from contractors, et cetera. So what that basically says is that if the government likes the 10 proposals they get in the first place, they'll make an award decision. If none of them are quite right, if you've got a Goldilocks situation, they're going to knock out the ones that are outside the competitive range. They're going to take the best ones, they're going to open discussions, and then they're going to get revised proposals from those. So if you make it into the competitive range, if you're one of those 8, then you're kind of trucking along, not anything you necessarily need to worry about. But if you're one of those 2, if you are excluded from the competitive range, you don't want to wait until the protest continues down the timeline and, amongst those 8, somebody gets an award. You need to kind of take your jump off point. You need to start down the path to a pre-award protest based on exclusion from the competitive range at this point. And we're going to talk, when I say you got to start down the path, when we get to deadlines, we're going to talk about what that path is. But again, just be aware, this is your jumping off point if you are told that you are excluded from the competitive range in a FAR Part 15 procurement. Now we're going to get to the type of protest that everyone is most familiar with. And like I said, one of the reasons that we cover everything up front, do that little primer, is that I see a lot of contractors who know a lot about post-award protests, and they don't know anything, or they're not they weren't sure that there's a difference between post-award protests and the 2 types of protests we just covered. So this might be a little bit more familiar to those of you, who have been in this industry for a while than the other 2 that we just talked about. But it's really important to understand all 3 types of protests and how each of them work, and also the deadlines and kind of the processes and procedures that apply to each. So remember, we talked about, the process of solicitation is put out in the street. Was there a problem with it? Protest then. Then you submit your response to the solicitation. If you've got a FAR Part 15 procurement where there's competitive range and you make it through, all right, you keep on trucking to this phase. If you get a notice saying that you were knocked out of the source selection, keep in mind that's your jumping off point, which we will circle back to in just a little bit. But most of you are going to be dealing with situations where you get all the way through to this point and you get an unsuccessful offer notice. You get something that says, hey, sorry, thanks for playing, but we chose your competitor instead of you. We really appreciate you competing for this requirement, but thanks, have a nice day. Don't pass go, don't collect $200. This is where you're going to start looking into whether or not you have a post-award protest. And even though, competitive range protests, are the earlier jumping off point, both them and post-award protests have similar basis. And by that, I mean they have similar things that are protestable, similar things that form appropriate bases for challenges. What is protestable is going to depend on the nature of the procurement. Remember that I said up front, one of the most important things to keep in mind when you're talking about protests is what section of the FAR am I under, what type of procurement is this? And the reason that that's important is it's going to have an impact on what the government should have been doing in terms of evaluating offerers. When you're talking about FAR Part 14 procurement, the government is supposed to be saying, all right, are you responsible? Check. Are you responsive? Check. Now I'm just going to take the lowest bidder, whoever's cheapest. If you're dealing with a FAR Part 15 procurement where it's the best value, that doesn't mean cheapest. That means a trade-off analysis or, a comparative analysis of price and non-price factors that are valued, with the relative importance that's going to be spread out or spelled out rather in the solicitation itself. So it's always going to be about, did the agency follow the solicitation stated evaluation scheme, and did they follow applicable law? In other words, if it's a FAR Part 15 competitive procurement or a commercial items procurement using FAR Part 15 procedures, and they tell you here are the evaluation factors, we're going to be looking at technical approach, we're going to be looking at staffing plan, and we're going to be looking at past performance. And that's in descending order of importance. In other words, technical is most important, then staffing, then past performance. And all three of those put together are as important as price. And we're going to do a best value trade-off. What's going to be protestable, or what potential arguments you have to say that you should have gotten the award, are going to be driven by that framework, by the framework that was put in place in the solicitation, by the way that the government stacked up the factors, and then how you were rated with regard to each of them. But what is protestable? There are some common themes. When you're dealing with non-price evaluation factor issues, they're pretty much always going to relate to how the government evaluated you and evaluated the awardee, and what ratings you got, how the best value decision was determined, and how they ultimately decided that they were the person given the evaluation factors. The awardee was the person that was going to get the award. So one thing that comes up often is unstated evaluation criteria or unstated sub-factors. In other words, the government said we're going to be looking at technical approach and staffing and past performance, but you get there and they seem to also be looking at whether or not you have any geographical experience in that particular area. Or maybe it's not as obvious or glaring as that. Maybe they said that they're going to be using technical approach, and they gave 3 things that they were going to be looking at with regard to technical approach, but they really seem to have looked at 5. And you had no idea they were going to look at those other 2 things, or you would have included that in your proposal. You would have, spent more pages on, kind of elucidating that you had experience with those 2 items. That's an unstated evaluation criteria or an unstated sub-factor. An error in applying evaluation criteria or assigning ratings. That's going to be a comparison of how it seems like the government rated you and what they said they were going to do, or how they said they were going to rate people in the solicitation. Again, it all is dependent on the solicitation scheme. So, for example, you've got a situation where, it's just, like I said, take an example. They say that they're going to be looking at, your technical approach, again, using the example that I was using before, and they're going to be assigning strengths and weaknesses based on, certain items. And when you get your debrief, which we're going to talk about in just a few minutes, you get your debrief and they say that they assigned you 3 weaknesses, and they defined the different ratings that you could get, excellent, satisfactory, marginal, or unacceptable. And as long as you had no more than 3 weaknesses, you should have gotten acceptable, but they gave you a marginal. That's an error in applying the evaluation criteria or assigning ratings. The government deviated from the solicitation scheme and they gave you ratings that were not justified by the definitions or by the criteria that were outlined in the solicitation. Unequal or disparate treatment of offerers is a big one. This is where you basically can show, hey, you're not treating me and the awardee equally. And this is one of those areas where you can really show more of an apples to apples objective comparison. In other words, go back to my example. What's factor 3? Past performance. And you're able to show that you have 5 projects in the last 1 year that were all over $10 million, and you got across the board excellent CPARs for every single one of them. And you got a substantial confidence satisfactory confidence for that. 5 projects in the last year, all over $10 million, all of which you got excellent CPARs, and you get a meh satisfactory confidence. Meanwhile, the awardee has 2 projects that were both over $5 million, but it's the last 5 years, which is less relevant for the purposes of this solicitation. And they had, a mixed bag of CPARs, but they got substantial confidence. That is unequal or disparate treatment. That's, hey, you were holding me to a higher standard. Hey, I can show that I am objectively better and somehow I got a worse rating, or I am objectively better and I got the same rating. You should have given me higher marks. This is an objective apples to apples thing where I can show you're not treating me the same. You're giving them all the benefit of the doubt, and me, you're looking for reasons to grade me down. The final one, and again, this isn't an exclusive list, but these are some of the most common things that come up and some of the easiest for contractors to spot, is remember competitive range. I said that they could open discussions. The agency could open discussions with the people who were selected for the competitive range, and then they could have them revise their proposals, et cetera. Well, if they open discussions, they need to be meaningful. In other words, they actually have to give the contractors a fair idea of what the issues were and what they would need to fix in a final round. They need to not be misleading, and they need to be even. In other words, you can't tell one contractor, yeah, we didn't love your proposal, you should probably try to fix it, and let them try to figure out what they need to do better, and sit another one down and go through with them in great detail exactly what they need to do to make their proposal better. Obviously, that seems to be showing benefit and showing favoritism to one contractor, right? So the agency is not allowed to do that. If they open discussions, they need to be even, and again, no disparate treatment. Price evaluation issues, when price is a factor, which usually it's going to be. Price reasonableness, price realism. In other words, and price realism is only required under certain types of contracts, so you're going to have to check with a legal professional to see if that's an issue. Escalation rates or adjustment of escalation, balanced pricing, and then the hub zone preference can also be a price evaluation issue. And you're going to want to talk to, once you get information and once you're exploring whether or not you have a protest, these are all things you're going to want to flesh out with an attorney and say, hey, what issues do we have? Where do I think I stand? Is this a good protest? Do I have a valid basis? All right, so let's move on to, I think, what one of the biggest questions that contractors have is, and that is, what is the deadline to bring a protest? And unfortunately, like a true lawyer, my answer here has to be, it depends. But I'm going to give you some guidelines to hopefully figure out what it depends on. The deadline is going to differ depending on a lot of the factual circumstances and a lot of the answers to those fundamental questions that I posed right at the beginning of this presentation. The general rule, and by that I mean the general GAO rule, just remember I'm kind of defaulting to GAO here, is that the protester needs to file its protest not later than 10 days after the basis of the protest is known or should have been known. So many of you out there, I'm sure, have this idea in your head that it's 10 days after your debriefing. That's not wrong, but it's only wrong for certain protests falling under a general exception to the rule, or an exception to the general rule. The general rule is 10 days after you know or should have known the basis for your protest. If you're not dealing with the exception, the debriefing exception, which we're going to talk about in just one second, that means 10 days after the award notice, 10 days after the announcement, 10 days after the bid opening. The only time you have 10 days after your debriefing is if the debriefing was A, required, and B, timely requested. You do not always have the right to a debriefing. A debriefing is not always required. So if you're dealing with a situation where it was not a required debriefing and you waited, you requested a debriefing, you got one, and then you waited 10 days to file your protest, you're going to be late. You're going to have filed an untimely protest and it's going to get dismissed. It's very, very important to figure out, hey, am I under the general rule, 10 days from the award notice, or am I under this exception where if I wait and get a debriefing, I've got 10 days from the date of the debriefing? And again, remember, that's going to depend on whether or not the debriefing is required and whether it was timely requested. So obviously the question I'm sure you guys are asking yourself now is, well, okay, when is a debriefing required? This can be a tricky question. And the reason is it depends a lot on what part of the FAR you're under. Debriefings are absolutely required for any procurement under FAR Part 15, that's contracting by negotiation. They are also required if you're dealing with a task order or a delivery order under 16505, that's over $5.5 million. The 2020 NDAA, National Defense Authorization Act, actually is in the process of basically telling the government that they need to revise that reg to move that threshold down from 5.5 million to anything over the simplified acquisition threshold, but that hasn't been finalized yet. So right now, the only time debriefings are required are for task orders over $5.5 million and for FAR Part 15 procurements. If you're talking about FAR Part 8, GSA or FSS schedules, if you're talking about sealed bidding, if you're talking about commercial items, if you're talking about simplified acquisition procurement, debriefing is not required. You are under the general rule. Do not wait for a debriefing and then think you're going to be in time on a protest. The exception to that, and the reason that I said this can get tricky, is sometimes you might have a commercial items contract that's using FAR Part 15 procedures, in which case it can be a very, very hotly contested and factually specific debate about whether or not debriefing is required and what the deadlines are. It's really important to talk to a lawyer about that quickly to understand what your deadlines are and how you need to meet them. Remember the second piece, as I said, when is a debriefing required? And then when is a debriefing timely requested? In other words, when do you need to request your debriefing to be considered on time? Where'd it go? Sorry. That is going to depend on, again, what part of the FAR you're under and generally speaking, you know, how you were notified that you were in a situation. Remember we talked about the different jumping off points. If you are dealing with, hey, I was just excluded from the competitive range, you will get a notice that says you were excluded from the competitive range. You have 3 business days to request a debriefing in writing after that. Similarly, if you get a notice saying that you were an unsuccessful awardee, you know, the notice that says, hey, we gave it to your competitor instead, that is, once again, you've got 3 days to request in writing your debriefing. If you fail to do that on time, your debriefing is not timely requested. Even if it was a required debriefing, you didn't ask for it on time, so you are going to be considered out of luck. All right, so a quick recap on protest deadlines. Pre-award based on solicitation errors, you need to submit before the deadline to the response to the solicitation. Otherwise, you're looking at 10 days from either the general rule, 10 days the day you should have known the basis of your protest, or if you fall in that required timely requested debriefing categories, 10 days from the conclusion of your debriefing. And keep in mind that I have underlined there conclusion of your debriefing, because when we get to debriefings, we're going to talk about the fact that word can be a little confusing. All right, so I know that's already a lot of information coming at you, but the other important thing to keep in mind is, what if you want an automatic stay? We've been talking about just how to get your protest in on time. But if in addition to getting your protest in on time, you actually want to take advantage of that automatic stay, which means that everything is put on pause while you litigate your protest. In other words, you know, for example, let's say you're a construction contractor and your competitor just got a job. You don't really want them breaking ground while you argue about who should have gotten the award. You want everything put on pause while you litigate the protest, and then hopefully, you know, if you get the award, if you win the protest, you can start and you don't have to be taking over a job that someone else started. Basically, an automatic stay is a pause of going forward with the procurement while it's litigated, while you do the GAO litigation. If you file within 5 days instead of 10, you get that automatic stay. So I'm sure 10 days already seemed like a pretty quick turnaround. Even for lawyers, that's a pretty quick deadline to have to deal with. If you actually want the automatic stay, you're talking about an even shorter deadline. You're talking about 5 days from the conclusion of your debrief, if you're in the debriefing exception, 5 days from the day that you knew or should have known the basis of your protest otherwise. And just for those of you who have been kind of wondering about size and status protests on the side, we're focusing on bid protests here today, but if you're wondering, you get 5 business, not calendar days, but 5 business days to file a size or status protest once you get a notice as well. So, and I should also note that when we're talking about these 10 days or 5 days for the automatic stay for bid protests, those are not business days, those are calendar days. Now, if the deadline falls on a weekend or a holiday, it gets pushed to the next business day, but you have to count weekends in calculating these deadlines. They are very, very quick. So now that we've talked about when you are entitled to a debriefing, let's talk a little bit about what you get in a debriefing and what you don't get. I'm not going to read all of these because you're going to get the slides and your eyes would glaze over. But the important thing to keep in mind is that this is the slide dealing with pre-award debriefings. The next slide deals with post-award debriefings. You get different information depending on where you are at in the process. You get less information if you're doing a pre-award debriefing because of an exclusion from the competitive range. Pre-award debriefings, you get agency's evaluation of significant elements of your proposal, and you get a summary of rationale. You're not going to get number of offers, identity of other offers, content of other offers, proposals. You're not going to get a ranking of other offers or an evaluation of other offers. In other words, you're really not getting anything about anyone else except for yourself. The most important thing on the left-hand side is this last bullet point, reasonable responses to relevant questions. And you also want to keep in mind the final bullet point on the right-hand side. They're not going to give you any trade secrets or privileged information. You know, debriefing is not a tool to gather information about your competitors so that you can rip off their billing, system or their pricing system. Post-award debriefings, you get a little bit more information. You're going to get the government's evaluation of your significant, weaknesses or deficiencies. You're going to get, for both you and the awardee, the overall evaluated cost or price and technical rating, and you're going to get the overall cost, price, technical rating for both you and your competitor, for the awardee. You're also going to get, for just you, past performance information. You're not going to get information about, at the debrief stage, about how they evaluated the past performance of your competitor. If there was an overall ranking, you'll be given that. You'll also be given a summary of rationale for reward. If you're dealing with commercial items, they're supposed to give you the make and model. And then again, the most important thing to keep in mind is the reasonable responses to relevant questions. So take away from this that this is your opportunity in a debrief to ask questions about things that seem fishy to you about the procurement. If you think that it looks like they didn't evaluate things correctly, work with an attorney or work with a consultant or work with your proposal manager, whoever makes the most sense for you, to come up with questions and really try to lock the agency down on what they did and did not do so you can assess whether or not you have a valid basis for the protest. Also, keep in mind, again, debriefings are not going to be a tool post-award for gathering confidential or proprietary information, and they're not going to include a point-by-point comparison comparing you to the awardee. You're only going to get the information that I just went over. So pro tip, always get a debriefing, even when you win. I guarantee you, even if you were the best offer, you weren't perfect, you can learn for next time. But obviously, especially if you lose, you want to get a debriefing that's going to give you the information you need to figure out, do you have a basis for a protest, and is it worth it to protest? The other thing to keep in mind, remember that I said conclusion of your debrief when we were talking about deadlines. If you fall in that required and timely requested debrief exception, you've got 10 days to file your protest, and that deadline starts ticking at the conclusion of your debrief. As of 2018, the DoD published an enhanced debriefing deviation. And what that says is anytime you get a debriefing from a defense agency, you then have 2 days to ask additional questions. The government then has to answer your questions in writing. and your conclusion of your debrief doesn't end until you get those answers. So in other words, you have the ability to put together additional questions, follow up from the debrief, get those answers, and then start clicking, or then your deadline starts ticking, not from the day you actually get off the phone or you get your written debrief slides, et cetera. Now, it's a little bit different for non-DoD procurements. Non-DoD procurements don't have that same thing that allows you to ask questions. It therefore becomes, I should say, doesn't allow you to ask questions after the quote-unquote debrief. So way more important to come prepared to a debrief for a civilian agency. If you get a written debrief, you want to be able to ask, hey, can I ask questions? And you want to try to get the agency to confirm that basically they'll act the same way that the DoD does. In other words, if I ask questions, can I assume that my debrief doesn't conclude until I get answers? Sometimes they'll say yes, and then that gives you some extra wiggle room. If you don't get an answer, then you have to assume you're back on the old deadlines and you just have 10 days from the actual day of the debrief, whether that was a written debrief or a phone call or whatnot. Many clients ask me who should attend a debrief, and obviously if it's written, that's irrelevant, but if you're talking about in-person or telephonic, I don't know if most lawyers feel this way. I know most lawyers I've worked with have felt this way. I do not recommend having an attorney there. I think it has a chilling effect on what people are willing to discuss. I think it's better to just have the contractor and to have them be taking very careful notes and to have them be prepared by an attorney ahead of time about what they should be listening for and what questions they should be asking. In terms of strategy issues, the things you're really going to be wanting to do, again, the most important piece is that reasonable responses to relevant questions. Use this as your opportunity to ask all of the questions that you have. Obviously, you don't want to be wasting their time and asking things that don't impact anybody, but if you think there were problems with the procurement, really use this opportunity to explore them. All right, so moving on from debriefs, you've got your information now and you think you have a protest. What do you actually need to file? We know when you need to file it, but what do you actually need to file? And again, that answer is going to differ by forum depending on where you're at. If you are going to the agency or the GAO, it's typically going to take the form of a letter. Now, it's going to be a longer letter. You're going to have some legal argument in there and a lot of facts laid out, but it's going to be a letter. If you're going to COFSI, you need to file an actual complaint the way you would before any court. Also, if you're seeking a stay, at GAO, as long as you file within that 5-day deadline, you automatically get the stay. If you go to COFSI, you actually have to seek a stay. And in order to do that, you have to file a motion for temporary restraining order, a motion for preliminary injunction, a memorandum of law, et cetera, et cetera. So you can see how protests before COFSI get a lot more expensive, a lot quicker. That is another reason why many people prefer to just go to GAO. What about substance? No matter where you file, whether you're filing COFSI in complaint form or whether you're going to the GAO in letter form, you're going to want to make sure that you put as much information in there as possible. You need to get past the speculation level where it looks like you're just throwing a bunch of stuff at the wall and seeing what sticks. You're going to want to be as specific as possible, and sometimes that's going to mean some logical extrapolation from the information you got in the protest, but if you're just making stuff up, your protest is going to be dismissed. A guy that I used to work with used to say sometimes you don't know if you have a protest until you file a protest. And what he meant by that is sometimes if you know that there's enough wrong that you can logically extrapolate and put together a protest, you're going to get to the next stage, you're going to get the agency record, and then you're going to be able to figure out if there was more wrong. That's still sometimes a viable gamut. The problem with that is that the government has become a little bit stricter about what government documents they will give you as part of the agency record. But all of this is a balancing act, and you really need to think about, what is a protest worth for me? How much do I know? How much am I guessing? How much is this going to cost? And how important is this contract to me? Do I really want to fight it? Also, one of the things that you're probably going to want to do is, the best protests include a specific request for documents, all of the specific source selection documents they want to see. They don't leave it up to the government. All right, so let's say you filed your protest. What happens next? File your protest. There might be a request for dismissal if you were either untimely or if you, like I just said, are too speculative. Let's say you get over that request for dismissal, or let's say that you don't have one of those issues and there is no request for dismissal. The next states, it's going to happen 30 days after the protest is filed, is that the agency is required to submit an agency report, which are all the source selection documents that led to the source selection decision. And they've got to do something 5 days in advance where they kind of say, here's all the documents that we are providing. That's why you want to do that request for specific documents, because if you do that, you know, you're going to have to get a specific response to that. As the protester, you have 10 days after you get that agency record to say, yep, here's all the stuff that proves exactly what I was saying in my protest. These are my comments to the agency report, basically showing that everything I said in my protest was correct, and here's everything in the agency report that proves it. And if you go, oh, wow, that gambit paid off. I not only filed a protest about the stuff that I knew, but I have an additional protest because I filed a protest and I now see the agency record, and there's all sorts of additional errors that I didn't know about and I couldn't have known about. And now I'm going to file not only my comments, but a supplemental protest laying out all the problems with the stuff that came out in the agency record. Sometimes if there's a supplemental protest, there'll be additional briefing, sometimes not. And then you ultimately get to the decision phase. The decision phase happens 100 days after the protest was filed. So these move very quickly. They're very condensed litigation. If you win, what happens is that the GAO goes back, or the Court of Federal Claims goes back to the agency and says, take corrective action. And what that basically means is fix this. They're not going to say, make an award to the protester. They don't have the ability to do that. All they have the ability to do is send the agency back to the drawing board to do a new source selection decision. Now, sometimes what the agency might do is once they look at the protest, they might say, oh, you know what? You're right. We messed up here. We're not going to wait for the GAO or the Court of Federal Claims to tell us that we messed up. We admit it. We're going to take corrective action of our own, you know, voluntarily take corrective action. So sometimes this whole process that's on the left-hand side gets short-shifted, gets, you know, kind of cut in half, because the agency just goes, you know what, before we even do a request for dismissal or before we even do an agency record, we're just going to take corrective action. The other thing to keep in mind is in really rare occurrences, the GAO will sometimes require a hearing. You might have to have hearings if you go to Court of Federal Claims, especially on the injunctive relief issues. I once had a protest where the GAO wanted all the parties, it was a consolidated protest, so there was a lot of protesters, to get on the phone. And they basically just walked everybody through the arguments and kind of telegraphed to the agency that they should take corrective action and not make the GAO write a 50-page opinion. I've never had that happen before, but you know, there are oddities that sometimes occur in the protest process, but generally speaking, you're going to be dealing with what we just talked about. So a final tip, and I know we're a little bit short on time, but I'm going to just take the extra 5 minutes to talk about the defending a bid protest, so please stick around. Final tip before we move on to defending a bid protest: don't pursue a losing protest. One of the biggest mistakes I see clients make is that, you know, they want to go full throttle on every potential protestable issue that they see. And, you know, they want to hire me and, you know, pay me to do that. And obviously, obviously I'm happy for the work. I'm happy to help any client with anything they want to do. But I view it as my job to tell them when, hey, look, this is silly to pay me to do this. It's not going to result in ultimately any benefit for you. There are jurisdictional issues. For example, if there's a task order that's under $10 million if you're dealing with civilian, or under $25 million if you're dealing with the Department of Defense, you can't protest it. If you're not an interested party, you have no standing. So if you're not in line for award, if you wouldn't have gotten the award anyway, if you're ineligible for award anyway, you're going to get kicked out on standing. If there's no competitive prejudice, in other words, if you can say, look at all of the very many mistakes the agency made, and the agency can come back and say, yes, and if we corrected every single one of them, you would still be in a worse position and we still would have given the contract to the awardee. So none of these errors made any difference. The same result would have applied. That's a lack of competitive prejudice. That's going to mean that you lose the protest. Sometimes it makes sense to know when to let it go. You're going to want to weigh the cost versus the likelihood of success. And you're going to want to think about what a win looks like. Sometimes you're in a situation where the government, you know, you can win the protest on a technical loophole or the fact that there's no documentation. And like I said, the GAO is not going to say, well, now you have to give the awardee to the protester. They're going to say, nope, agency, you've got to go back and reconsider the award decision. And what the agency is going to do is go back and make the same exact decision and document it better. And what did you do? You spent $50,000 or $30,000 or $10,000 in legal fees, and you still don't have an award. It just held up the process, wasted a bunch of your time that you could have been, writing new proposals for new jobs, and it didn't result in an award to you anyway. So it's really important to think about this as a practical matter, not just a legal matter. Just because you can file a protest doesn't always mean you should. You also want to just talk to your lawyer about whether or not you can take it in stages. Can we file the protest and see what we get in the agency record and then evaluate whether it's worth paying you to do the comments? Can we file it and see if we can get past the motion to dismiss phase? Can we file it and see if it scares the agency enough to take corrective action, and then talk about whether it's worth, spending more money to go forward? The key is really to talk to your lawyer at every stage and reevaluate at every stage if it's worth it. The colleagues of mine and the peers of mine out there that are willing to do that are the ones that are, going to guide you through this process better. All right, so in our last few minutes, I want to quickly cover defending bid protests. When your award is protested, thus far we've been talking about when you don't win an award and you're trying to protest, the other party that got the award. What happens if you're in their shoes? What happens if you just got the award, you're celebrating, you're popping the champagne, and then you get notice that your award has been protested? What do you do then? And this is another area where I see a lot of contractors make a mistake because they don't realize what role they can play. The protest is technically against the agency. Remember I said that when a protest is filed, agency counsel, the lawyers for the Corps of Engineers or the lawyers for the State Department or the lawyers for the VA are going to step in and defend their own award, right? Even though you, the awardee, ultimately benefited from this because you got the award and you're going to get the money and you're happy and you're celebrating, you didn't have any control over the agency's source selection process. You benefited from it, but you didn't control it, which means that it's going to be a little bit hard for you to argue that the agency did anything wrong. That's the agency's job to step in and do that. But that doesn't mean that you can't help. The protest is technically against the agency. Government counsel is going to be stepping in to be the party defending the protest. They're going to be opposing counsel to the protester. And yes, many contractors are like, well, then why wouldn't I just sit back and let them do that? And you certainly can. That's an option. You don't have to get involved. But it's really, really smart to get involved. And that is because you need to protect your rights. Right now, as soon as the protest is filed and the agency counsel is like, nope, we're going to defend this award. I agree with you. You should keep the award. Your interests are in line. You guys have, the same interests, the same goals. Keep the award with you. Defend the protest. And if it stays that way, that's great. Awesome. Maybe you don't need to do anything. But what if the government starts looking at the protest and going, uh-oh, maybe we did mess up. Maybe we need to take corrective action. If they decide to take corrective action and you're not a party to the protest, no one's going to be there to speak up for you. You're going to have the protester saying, take corrective action. And you're going to have the agency saying, yeah, maybe we should take corrective action. Maybe we should take your award away. And nobody's sticking up for you and saying, no, you shouldn't. I should keep this award. So what you do to get around that is you do something called intervening. And the takeaway here is you should always intervene if your award is protested. And the reason for that is it's really simple to just get your foot in the door. It's a simple, short, one-page filing that should take your lawyer, an hour tops. That's a jumping off point for the lawyer to cultivate a relationship with the agency counsel, and it's a way to keep an eye on the docket and see what is happening. If the agency continues to defend your award, if the agency is like, nah, I got this, and you're reading the briefing and you're like, no, they're doing a really good job, I don't really have anything to add, then you don't have to do anything. Then all you need to do is talk to your lawyer and say, okay, so they're carrying the water for us? Great, don't file anything. I don't want to pay you for 10 hours of legal work that we don't need. But if something goes wrong, you're poised to jump in and fix it. You have the ability to kind of get your foot in the door and modulate your efforts depending on what you see the agency doing, if you see them representing your interest, if you see them letting stuff slip through the cracks, or if you see them changing their tact. As an intervener, you have the ability to help with defensive arguments, and they're all going to stem from the things we talked about, from the flip side during the first part of this presentation. If any of those complicated rules that we talked about in terms of protest deadlines, if the protester messed that up, talk to the government, have your lawyer talk to the government counsel. about, hey, shouldn't we be trying to do a request for dismiss on timeliness? Hey, similarly, this is all speculation. We should be doing a request to dismiss based on speculation. Standing or jurisdiction, and not, again, should we be doing a request for dismissal if you aren't an interested party, if you aren't in line for an award, if you tried to protest the task order that's under those dollar thresholds that we talked about. And then all of the same things that I just said, that when you're a protester, you need to say, whether this protest is really a good win for me. When you're on the other side, you should be thinking about all of those same things too and say, do these give me the ability to fight the protest? Is there a lack of competitive prejudice? Can I say that this should be an agency discretion issue? Did they make piecemeal arguments? Did they not diligently pursue information? What defenses do I have? Is the government covering all of them? Is the government giving me the best chance possible to keep my award? If so, great. We don't have to do anything. We're just monitoring the situation. If they're not doing a great job, I want my lawyer to step in. They're a party. They've intervened. I'm involved, and I'm poised to fix whatever problems come up and to represent my interests. The final piece is that even if you don't really have any of those substantive arguments that I just went through, there's still some protest litigation tactics that you can be used, the types of things that everyone hates lawyers for, the procedural loopholes. If you're an intervener, you can talk to the agency and say, hey, look, can you fairly limit the documents in the agency report? Remember I said that, the whole quote unquote, you don't know you have a protest until you file a protest. If you're the protester, that's great. You want to use the protest as somewhat of a fishing expedition to get documents and see if you can come up with any more issues. If you're the awardee, you want the exact opposite of that. You don't want to let the protester go on a fishing expedition. You want to say to the government, they protested these 3 things and these 3 things only. They should get the documents about those 3 things only. Let's not give them any additional information that they could make into additional arguments. And there's a proper way to do that. And then finally, if the stay is really important to the protester, sometimes if you can defeat the stay, they kind of lose their will to continue the protest and they might drop it. So with that, I know that we went a little bit over, and I know that I was going to leave some time for questions. I will stick around for a couple questions right now, but if I don't get to your questions, and if you've got questions that come up after today, my contact information is on the screen. I've got to go out of full screen mode to get to the questions because of this Zoom issue. But with that, I'm going to see what questions we got, if I can get to the questions.
Yeah, we do have one question, so.
All right, I don't know what's going on, but I can't get to it. Would you mind reading it to me? I'm sorry.
No, not at all. Most valid protest bases include how well your proposal was evaluated and ranked in relation to others. Since debriefs are prohibited from disclosing this type of info, how would we know if such discrimination or bias was present?
Yeah, it's a really good question. So the way to get that kind of information is you're not going to obviously be able to ask in the debriefing, I need you to walk me through how you compared me to this other offer. What you want to have them walk you through is, okay, you said I had 3 weaknesses. I want you to tell me all of the reasons that you assigned me 3 weaknesses. And I want you to explain to me why 3 weaknesses resulted in a satisfactory rating when it should have resulted in, whatever levels above that. You're going to want to break it down into more tiny factual pieces, because you're never going to get the government to agree with you or share information during the debrief that basically is like, yes, we disparately, we used disparate treatment in evaluating you, or yes, we evaluated you in a different way. What you're going to want to do is break it down into tiny factual pieces that then your lawyer and you can build up into an argument. Some of it is going to be logical extrapolation. In other words, if you know your competitor, and I know a lot of you out there know a lot about your competitors, if you know your competitor just had really bad past performance on the incumbent contract, because that's the scuttlebutt in the industry, and you know that you got a past performance of, satisfactory confidence, and you know that you got rated really well on everything else, you can say, okay, this makes no sense. I know what they got rated on technical, they're the same as me. I know what we got rated on staffing approach, they're the same as me. My price is better, And the only thing you didn't tell me about them is their past performance, but I know this thing about them, and there's no way that they could have gotten as good a past performance evaluation as me. And if I'm equal on the other factors, how could I possibly, with a lower price, equal on 2 factors, and I should have had a better rating on the 3rd factor, how could you possibly have given the award to them? So it's really about breaking it into logical pieces and then building up a logical argument. That's why it's really, really important to come into the debrief prepared to ask detailed questions and have detailed follow-ups and hold the government accountable to answer detailed questions.
And Maria, we have a compliment from one of our participants who has said that he's been involved in defense programs for more than 30 years, and this is one of the best presentation of the subjects that he's ever heard. So,
well, thank you very much. I appreciate that. I know it's a lot to cover in a short amount of time, and that's part of the reason that people are so interested in protests and that, you know, protests are so difficult, is that there's so many, you know, rules with 5 exceptions and so many different things to keep in mind and so many moving pieces. But I'm glad that you enjoyed it. And for those of you who have questions that we didn't get to answer, like I said, I know it's a lot of information coming at you all at once. Please feel free to reach out to me. My contact information is on the screen. You can also follow me on LinkedIn or Twitter, where I share when I'm doing other presentations such as this, or I share our weekly blog posts about small business and government procurement issues. And I guess with that, doesn't seem like we have any other questions.
no, I think you will be getting
much.
emails, Maria, but you know, one thing I always take away is, you know, the lawyer is your best friend. So
at least in some contexts, yeah, I wouldn't say that's across the board the case, but I think in this, you know, the sooner you involve an attorney in the bid protest process, the less likely you are to have something go wrong. I mean, you see how many different catalyst points there are and how many different deadlines and how many different questions you have to ask to try to figure out the deadlines. And I hate when, you know, contractors come to me and they say, oh, you know, we just got this award notice and there was a problem with the solicitation. And I'm like, yeah, you kind of needed to ask me 3 months ago. There's not much I can do for you at this point, you know? So yeah. I hope that this has saved all of you guys out there from some mistakes. And if you've got questions, please feel free to reach out to me. Archisha and Layla, thank you, and thanks to FedMine for hosting. This has been a wonderful experience working with you guys, and I really encourage everyone to reach out to you guys too if they need industry insiders.
No, thanks so much. And for those you know, that are here, we did 2 other webinars with Maria. They're all on our website. And thank you, and enjoy the rest of your afternoon.
All right, thanks everyone. Bye-bye.
Bye.